All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
Bill, we're going to have a little bit of fun with Lawyer on the Clock today, but let's get to the serious part first. The first one I want to talk about is a settlement of a case, and this serves as a reminder to all employers out there. Amazon workers at two warehouses in Kentucky and Pennsylvania at their fulfillment centers, 21,800 Amazon workers settled a case with Amazon for $7 million involving time spent in security screenings that Amazon was not paying to their employees.
Security screenings mean what, Burt?
Meaning that the time that they spent waiting in line when they either came into the facility, or more importantly, when they exited the facility, the time spent waiting in line for that and actually going through the security screening to make sure that the employees were not stealing from the Amazon warehouse.
So Amazon was stealing wages, making sure their employees were not stealing their goods.
Yes, in essence, that's kind of what the case boiled down to. They did settle the case with these 21,800 workers. Each worker will get about $130 on average. Out of the settlement. The deal, of course, provides for nearly $2.4 million in attorney's fees, which is about 33% of the settlement fund. But the bottom line here
is the lawyers always win, Burt. We know that's the case, right? I mean, that's why you picked your profession. I love it. Yeah.
Yes, of course. And the interesting thing here is this does serve as a reminder to employers that if you are putting your employees through security screening at work, that is time that's compensable. And so the case law is very clear on that.
All right. So security screening, but let's just expand this a little bit and help out our listeners, because it's not unusual. I've seen it, particularly when I was working in very large manufacturing environments. I might have a line of 30 or 40 people waiting to clock out, right? To scan their badge, punch a time clock, all the methods that are used today. And that might take, 5 or 6 minutes for everyone, 7, 8 minutes to go through the line, depending on, where you're at in the line and what time of the day, what shift. Does this apply to that? I haven't clocked out yet. I'm in line. Am I still on the clock?
Yes, and that's interesting because clocking out, of course, that solves the problem for the employees. That's in their favor because they're actually on the clock. They're waiting in line to clock out. If they're waiting in line to clock in, that gets a little bit more difficult. But you do have the argument that that technically that time should be compensable, but if it kind of washes out at the beginning and the end of the day, then the employer should be fine. But they have to have documentation and proof to be able to support that.
Right. Yeah, because you do get it on both sides, right?
Correct.
I mean, people usually, the line often is a little bit longer, at one time of the day or another, depending on, people coming or going and what's happening. But I know the line starts early.
Yes.
When you're clocking out, and it starts late when you're clocking in.
Yes, for sure.
Yeah. So, any good practices that we need to be aware of for something like that? Is there a standard grace period? I know a lot of timekeeping systems will say, well, we track time every 6 minutes, that type of thing. And
there's a rounding up and a rounding down rule, in 15-minute increments. But by and large, most systems are really able to track to the minute, a second these days, and so rounding isn't as much of an issue as it used to be. But if you are using rounding, make sure you're doing it carefully and getting legal advice on how to do that properly.
And I think there's probably a difference between I'm just waiting in line to clock and leave versus I'm actually waiting for my employer to screen me before I can go get in line to leave.
Exactly.
Yeah.
You're taking up my time, Phil.
Hey, all right. I'm sorry,
All
Bert.
right.
What else you
All
got
right.
for me?
No wonder I go over all the time. So another one I want to, this one also serves as an interesting reminder to employers. The First Circuit Court of Appeals, the Federal First Circuit Court of Appeals, heard oral argument yesterday on a case involving Trader Joe's. I thought this one was really interesting because in that case, an 80-year-old former Trader Joe's employee who was fired from Trader Joe's after she was caught buying beer for her underage grandson.
Oh,
Unpack that one
yeah.
for me,
Tell
Phil.
us
Yes.
more. Yeah,
All
tell
right.
us
All right.
more.
So in this particular case, the Trader Joe's fired this employee, this 80-year-old grandmother, for violating its alcohol policy when she let her grandson, who also worked at the store, pick out a 4-pack of beer and then purchase the beer for him so he could drink it during dinner after their shifts ended. And,
Okay.
it seems like that would be something that would be a violation of their policies and their rules and could reasonably get an employee fired, wouldn't you say?
I would think that should be a violation. If it
Yeah.
was known that, hey, you are purchasing this to support underage drinking,
Yeah,
regardless if it
exactly.
was family or not. Randy, you got an
Exactly.
opinion on that? Randy?
Yeah, I'm here. I mean, it seems like it's definitely would be a legal issue. I was actually going to ask Bert when he mentioned Pennsylvania, but I'll take it offline. When I found out the other day that I was only getting half the potato chips in my potato chip bag, I heard on the news and I went in and opened it up and it was true. And now I've been furious ever since then. But I won't divert into my anger on that law that's going through the courts right now. No, I think that's a touchy subject. I mean,
So I assume it's illegal for me to buy alcohol from a kid. I remember when I was a kid, it was not unusual to stand outside the liquor store or a convenience store and ask some person that looked approachable if they would, hey, buy a 6-pack of beer for me and my buddies, right? That was illegal for them to buy that and serve to a minor. So I would assume yes.
The grandson, she's probably just getting the grandson back. Grandson probably bought the grandmother some marijuana. So,
Well, well, if he's underage, he's probably underage for both, and I don't know the rule in Pennsylvania.
Nick, there you go, talking about the wacky tobacco again.
Yeah.
So
we got to keep our eye on Nick.
So anyway, this case was really interesting because she did in fact get fired for this. She then lost her case on summary judgment at the trial court. And then, like I said, there was oral argument that was conducted yesterday on this case. And 2 of the judges during oral argument pointed out a very significant weakness in Trader Joe's case. And that's where it's important that we as employers remember that we treat our employees, Phil, you're gonna know that I say this over and over again, that we treat them what?
All equally and fairly, yes.
Consistently and fairly. That's exactly right. Consistency and fairness. And what the court pointed out from the briefing and made a big stink about this during oral argument, that the store records showed that 6 employees who were under 40 years of age were given warnings for violations of the exact same policy when they failed to check a minor's identification and sold the person alcohol. And the trial judge found that those examples weren't in the apples to apples comparison because the employee in this case had knowingly violated the employees while the other employees were examples of negligence. The Court of Appeals, again, and 2 of these judges, it surprised me a little bit, but they said no. They think that this is a violation of the exact same policy, even though the grandma here knowingly did it. Kind of gets to your point, Phil, about knowingly doing something versus the employees at the checkout line who just simply failed to check IDs. So we'll have to see how this case turns out, because I do think that there's a fairly significant factual distinction here, but it just goes to show employers the dangers of not applying things 100% consistently.
Yeah, that's a good one, actually. I like that angle, right? It's like, oh, I just happened to forget to check your ID, and maybe you happen to be my grandchild. Other one is I'm actively, letting you even select the booze that you want and then buying it for you.
Exactly.
Yeah.
Bill, we have time for one more.
Sure. One more quick one.
All right. Quick one. This one is the one I wanted to have some fun with you on, but
Go
you've
for it.
again eaten my time here. But
We're just
so
gonna have
so
to get you your own show, Bert. That's all I can tell you.
so the this one I'm doing a presentation in a few weeks at my firm's National Workplace Strategy Seminar on recording in the workplace, employees making recordings of their employer in the workplace, whether video or audio. And so I decided, Phil, based on your advice, to take advantage of all of this artificial intelligence out there. And so I wanted to know a question rather than having to go research it on my own. I wanted to know the answer to the question. So I typed in to one of these search engines that you use all the time on a daily basis to help you run AIM.
All
And
right, I
typed
got
in,
it up right here. All
all right,
right, pull it.
I typed.
What's the question?
I typed in the question, what was the first workplace recording case that made it legal for employees to record at work in the United States? Okay,
Yeah.
that's the question. Very simple. I just wanted to know what was the first case that held that it is lawful for employees to make recordings at work, despite employer policies that have that say that it's a violation of company rules to make recordings at work. And
Okay.
in the search engine, this Chat GPT said the legality of, I'm going to give you the answer here, what it gave me, the legality of employees making recordings at work in the US has evolved over time through various legal cases and legislative actions. There isn't a single quote unquote first workplace recording case that definitively established the legality of such actions nationwide. All right, then this one gets really interesting. However, one notable case that contributed to shaping the legal landscape regarding workplace recordings is the case of Kearney versus Salomon Smith Barney. In 2004, the Second Circuit Court of Appeals ruled in favor of Kearney, a former employee of Salomon Smith Barney, now part of Citigroup, who had recorded conversations with her supervisors regarding alleged discriminatory practices. The court held that Kearney's surreptitious recordings were not in violation of the federal wiretap laws because they were made for the purpose of documenting evidence of discrimination. Sounds like a great answer to my question, doesn't it?
Well, it sounds like a good answer, but I do know enough to know you're going to have to fact check that.
Uh-huh.
Okay.
Well, and it's a good thing I did, because I would love to have just been able to simply cite that case and put it into my presentation and go tell several hundred people that I'll be talking to that this is the case on the issue. So I did. I went and looked up the case of Kearney versus Salomon Smith Barney from 2004 from the Second Circuit that supposedly held that the employee was not in violation of a federal wiretap law because she was recording to document evidence of discrimination. And guess what I found, Phil?
Well, I'm going to guess you found the opposite.
I found the opposite. I found this case, and what this case was involved with was an appeal by two people who filed a class action against their company. And what it had to do was that the employees were accused of recording telephone calls between themselves and their Atlanta-based stockbrokers without the consent of the stockbrokers. And what they were doing is they were trying to get information about the conduct of the company. These were not former employees. And so what this case really had to do with was a jurisdictional dispute on which state's laws applied to the people who were making the recordings of these telephone calls. And there was a dispute between Atlanta and California law on this issue. It had nothing to do with employment whatsoever. But it was really interesting because that result that came up for me, it sounded confident.
It was convincing, was it not? Yeah.
It was convincing, and it was right on point for me. The problem is that it was literally made up.
Yeah, well, I think that is one of our challenges at this point is to make sure we We fact check our chat GPT responses, particularly when we're looking at it from a legal perspective. And Burt, if you read the rest of that, it always says it's not providing legal advice.
Correct, it does.
Check and do those things. So let's not get lazy into practice over there at Ogletree Deacons. And I know you won't. That's why we love you the best, and you do a great job. But that's a good reminder to all of us, because I do promote using Chat GPT. I use it every single day, but I am careful, and I do try to fact check things that are meaningful in the way that you just used it there.
Yeah, and I would say to people, I know a lot of people use it for checking, for letter writing and maybe even policy drafting. And, I would suggest to people that maybe it's a good starting point to get some ideas of what the issues are that should be addressed in a letter, or issues that should be addressed in a particular policy. But it is not a substitute for good HR practices, good HR advice, or good legal advice.
There you go. Not yet anyway. All right. So sounds like someone defending their position a little bit. Okay. Well done, Burt. I love
Thanks,
it.
Phil.
Hey.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link, aimea.org/This Week at Work, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.